There was some language changes over the past 48 hours.
Senate, please come to order. Good morning.
Good morning.
For today's devotionals, we'll have a moment of silence to collect our thoughts. Thank you. I was curious how quiet we can actually get. Papers and other things. Are there any announcements? Senator from Orleans.
Yes, thank you, Mr. President. Appearing on the calendar today is H877, an act relating to miscellaneous ag subjects. And I move that it be committed to the Committee on Natural Resources and Energy with the report of the Ag Committee.
Now, the Senator from Orleans moves that H877, an act relating to miscellaneous agricultural subjects, appearing on the calendar for notice, that the rules be suspended and the bill be referred to the Committee on Natural Resources and Energy with the report of the Agriculture Committee intact. Are you ready for the question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay. The ayes have it, and you have suspended your rules in order to refer H877 to the Committee on Natural Resources and Energy with the report of the Committee of Agriculture intact. We have no House bills for reference, I believe, which brings us to the orders of the day. I've been instructed that we will take up the third readings, which can be found on page 3571 of today's calendar first. The first one being H72. H72 is an act relating to harm reduction, criminal justice response to drug use. Are there any amendments before third reading? Seeing none, please listen to the third reading of the bill.
H72, an act relating to harm reduction, criminal justice response to drug use.
Now you've heard the third reading of the bill, and the question is, shall the bill pass? Are you ready for that question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay.
Nay.
The ayes appear to have it. The ayes do have it, and you have passed H72. We now have up for consideration H173. H173 is an act relating to prohibiting manipulating a child for the purpose of sexual contact. Are there any amendments before third reading? Seeing none, please listen to the third reading of the bill.
H173, an act relating to prohibiting manipulating a child for the purpose of sexual contact.
Now you've heard the third reading of the bill, and the question is, shall the bill pass? Are you ready for that question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay. The ayes have it, and you have passed H173. We now have up for consideration H655. H655 is an act relating to qualifying offenses for sealing criminal history records and access to sealed criminal history records. Are there any amendments before third reading? Seeing none, please listen to the third reading of the bill.
H655, an act relating to qualifying offenses for sealing criminal history records and access to sealed criminal history records.
Now you've heard the third reading of the bill. The question is, shall the bill pass? Are you ready for that question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay. The ayes have it, and you've passed H655. We are now going back towards the beginning of the calendar. We are, my understanding, passing over H534 and S30, which brings us to H661 on page 3454 of your calendar. H661 was read for the first time and was referred to the Committee on Health and Welfare. The committee has considered the bill and recommends that when the bill is amended, the bill ought to pass. Please listen to the second reading of the bill.
H 661, an act relating to child abuse and neglect investigation and substantiation standards and procedures.
Now you've heard the second reading of the bill. For the report of the committee, the senator from Addison.
Thank you, Mr. President. H 661, a bill about child abuse and neglect investigations and substantiation. The Family Services Division at the Department of Children and Families is responsible for helping to make sure children and youth are safe from abuse, have their basic needs met, and have the parental care, support, and supervision required to ensure their well-being and education. Each year, the Family Services Division receives thousands of reports of possible child abuse and neglect and must assess, investigate, and substantiate these reports to ensure the safety of children. Currently, if a report is substantiated, the individual's name must be placed on the Child Protection Registry. The registry is a statewide database containing records of all investigations that resulted in a substantiated report of child abuse and neglect on or after January 1st, 1992, to ensure that those who should not have access to vulnerable individuals, including children, are prevented from those opportunities. The registry includes various levels based on the severity of risk an individual may pose to the safety of children. Although the registry is an important tool for keeping children safe, there are strict consequences for having your name placed on the registry, including impacts to an individual's ability to get certain jobs, adopt a child, become a child care provider, provide foster and respite care, and work or volunteer in positions involving children, youth, and vulnerable adults. And just a reminder, all of that is to help keep children safe. But it's incredibly important because of these implications that investigations and determinations that lead to placement on the registry be accurate, fair, and sufficiently serious to warrant placement on the registry. There are concerns that the current process casts too wide of a net and may lead to too many individuals being placed on the registry, often with significant personal consequences. As such, H 661 would update, reform, and strengthen child abuse and neglect investigations after a recent analysis identified systemic problems associated with the current system of identifying instances of child abuse and neglect and the placement of individuals on the Child Protection Registry. H 661 addresses those problems in a fair and balanced way and ensures continued protection for Vermont's children and families. Over the past 5 years, a diverse group of stakeholders across Vermont, including DCF, the Vermont Parent Representation Center, attorneys involved with child welfare cases, community organizations and impacted individuals, and the Office of the Healthcare Advocate have been meeting to work out improvements in the process, resulting in an incredibly cooperative relationship between DCF and these vital community partners. This bill addresses several key reform areas. It adopts a preponderance of evidence standard of proof that aligns Vermont's with most other states. The current reasonable person standard is not objective or quantifiable, leading to different interpretations depending on the investigator and review teams. H 661 also improves the process for notifications, makes a more realistic appeal timeframes, has stronger rulemaking authority and administrative efficiency, and centralizes decision-making to achieve greater consistency across the state. The bill also gives the department discretion to not place individuals on the Child Protection Registry when a case is minor and doesn't pose a risk to child safety and well-being. Most importantly, H 661 ensures that individuals who are on the abuse registry are those who do pose an actual public safety threat to children. So we can turn now to the section by section summary of H 661, which can be found on page 3454 of today's calendar. Section 1 updates the Department of Children and Families responsibility regarding investigating complaints of neglect, abuse, or abandonment of children to include when, whether, and how names are placed on the Child Protection Registry. Section 2 updates the purpose for efforts to protect children from abuse and neglect to ensure that DCF investigations are thorough, unbiased, and based on accurate and reliable evidence and adhere to due process requirements. Section 3 increases, as I mentioned before, the standard of evidence from a reasonable person standard to a stricter preponderance of evidence standard, which is, as I said, a stricter standard of evidence consistent with what's used in most other states for substantiating child abuse cases, and means that the evidence shows that the underlying claim is more likely to be accurate. Section 4 updates the procedures for the investigation and requires DCF investigators to use their best effort to obtain the mailing address and the email address of the person alleged to be responsible for the abuse and neglect, and as soon as practicable, and mandates that the person being notified for the outcome of the investigation is provided notice and updates by their preferred means of communication. This section also requires that the investigation include all other pertinent data, including interviews of witnesses made known to the department. Section 5 requires DCF to adopt rules that determine when and how names are placed on the registry and the standards for determining a child protection level designation. Section 6 updates and clarifies the notifications and process regarding substantiations. Subsection A requires that the person alleged to have been abused or neglected a child is notified of the substantiation and child protection level assigned in the registry, the date they are eligible to seek expungement, and the right to request a review of the substantiation determination. This section also requires DCF to send notice to the accused person by first-class mail or by mail to the or regular email to the address collected during the investigation. And all notices must always also include ways for the person to contact the department for further information. Subsection C extends the timeline available to seek an administrative review to 30 days after the department sends notice of the right to review and gives DCF the authority to grant an extension for good cause not to exceed 60 days after the department has sent notice. Subsection D extends the time DCF has to schedule an administrative review conference to 60 days after receipt of the request for review and requires DCF to provide a copy of the investigation file at least 20 days before the conference. Further, the section outlines when an extension may be authorized, as well as the consequences for failing to appear at a review conference. Subsection E updates the standard of evidence for the administrative review to the preponderance of evidence standard. So this is the review of it, also has to use the preponderance of evidence standard and allows for remote participation if a person requests or if there's a declared state of emergency. And subsection F requires the department to disclose information about the investigation that is obtained by the reviewer outside the review meeting to the person requesting the review. It clarifies the process, make sure the notification system is better, make sure there's a realistic timeline for all of this to happen. Before, the timeline was so crunched that it didn't happen well. And section 7 of the bill allows the department to send notice of the review decision based on the method of contact requested by the individual. Section 8 updates and clarifies the process for expunging records from the registry and allows an individual to file a written request with DCF seeking a review to expunge a registry record. And the section also permits remote participation in an expungement conference upon the person's request or if there's an emergency. Section 9 removes the requirement for a written request for an expungement within 3 years for persons under the age of 18 who have been placed on the registry. Section 10 requires additional rulemaking for clarification. Section 11 requires a report from the department due back to the committees of jurisdiction later this year, examining the capabilities and resources necessary to safely, securely, and confidentially store any interviews recorded during a child abuse neglect investigation. Section 12 also requires a report on establishing a centralized internal substantiation process, substantiation categories, and identifying differences in substantiation decisions by the central and district offices. This is a way to make sure that there's consistency across the state. And the bill would take effect on September 1st, 2024, in order to give the Department of Children's and Families time to implement it. As I said before, this bill is a result of collaboration and cooperation from the Department of Children's and Families and a diverse group of stakeholders seeking to improve the process for investigating child abuse and neglect. It prioritizes child protection and safety while making the system more efficient, effective, and understandable for those who work in the system, engage with the system, and are impacted by the system. Your Health and Welfare Committee heard from a number of witnesses. I want to first call out Larry Christ, who's the Executive Director of the Vermont Parent Representation Center. He was crucial in the work of this bill and the work that's been going on for years to get to this bill, to get consensus across stakeholders and to really engage productively with the department. And likewise, the Department of Children's and Families, their General Counsel, Jennifer Micah, and their Child Safety Manager, Nancy Miller, and most especially the Commissioner, Chris Winters, engaged really productively and made this a priority to make sure that this system was working for children's families and people who were accused of child abuse and neglect, as well as everybody who engages with the system. We also heard from the Voices for Vermont's Children, as I mentioned, the Office of the Child, Youth, and Family Advocate, and other advocates, and of course, our amazing legislative council attorney, Ben Novogroski. Your committee vote was 5-0-0, and we ask for your support. Thank you, Mr. President.
Senator from Washington.
Thank you, Mr. President. Some of you may know at one point in my life, I worked with people struggling with parenting. It was a predecessor of Prevent Child Abuse Vermont. And at that point, almost anybody could put your name on the child abuse registry. And we did, when I was on health and welfare many years ago, we did some tightening up to make sure, because the consequences are severe, especially if you're you might be someone that might want to be a cafeteria worker. You don't have a lot of skills, but you can wash dishes. You couldn't do that in a school if your name had been put on the registry. There are consequences. And so it's important that we make sure only the people that are a real threat to children. And also, you pick up the paper now and you read stories of the police bringing home children age 10 and 12 that their parents allowed to walk 2 blocks to buy a Dunkin' Donut. We don't need those parents put on a registry. I had 4 of my grandsons, aged probably 8 to 11, on Easter Sunday, took the dog and went for a walk around the block. I find myself actually kind of expecting I might get a phone call telling me, do you know your kids are out unsupervised? Kids used to play in the neighborhood. They don't play in the neighborhood. And what's been considered child neglect now has really kind of mushroomed beyond what is truly child neglect that is dangerous. And so I'm glad we're making sure that people who aren't a danger are not going to be put on the registry.
Senator from Caledonia.
Thank you, Mr. President. May I inquire of the reporter, please?
The Senator from Madison is interrogated.
I'm looking at section 11 on page 3464. And I'm just wondering, in terms of the report, around safely and securely and confidentially storing any interviews. I understand that would pertain to the Department of Children and Families, but obviously there are many other players in the system, including our state's attorneys, maybe our SIUs and so forth. I was just wondering, was there any discussion around alignment or whether those practices around this protection of this information, how that same standard would be applied as it would relate to those other entities that are involved in the investigation of child abuse cases.
So this bill is focused on the administrative process that is gone through with the Department of Children and Families, and not there can be potentially a court process that is also happening that is parallel to the administrative process. And the court process would have different methods for storing their information and their evidence. So this was really focused on how does the Department of Children and Families store their interviews. So we didn't really take testimony on the sort of court process. We were really focused on the DCF process.
Thank you. I was not just talking about what happens in the court itself, but where other interviews and contact with that would perhaps lead to a case, a petition being filed regarding abuse or neglect of children. I was just thinking it would be nice if we had that same consistency of standards and security, but this is probably a discussion for another time.
Yeah, no, I absolutely agree with you. And the report section came over to us as this way from the other body. And I don't believe that the Senate Health and Welfare Committee made any changes to this section of the bill. Excuse me, we were focused on making sure the process part of the bill was really tight. So this section was not changed by your Committee on Health and Welfare. But if there are tweaks you would like to make before third reading, I certainly would be happy to talk with you about that.
Thank you, Mr. President. No, I don't intend to make any tweaks. I was just looking at sort of the consistency across all entities that might have the same kind of information as the Department of Children and Families. So thank you.
Question is, shall the Senate adopt the report of the Committee on Health and Welfare? Senator from Chittenden Southeast.
Thank you, Mr. President. I simply would like to emphasize the significance of this bill and how critically important it is for children and for families. The bill offers some predictability. It offers some objectivity to the registry and how the work is done within the agency. And the final report that will come back to us will include other folks, including those from the Department of Mental Health, including those from the Agency of Education and others, to offer further improvement. This has been a very contentious area for many years. And as the senator from Addison indicated, the work that was done outside of this building was critically important, and with real strong emphasis on the work that the commissioner of DCF has done very recently to bring folks together to improve this system. Well, Mr. President, we're very excited about this bill. It's an important step to take forward, and it will protect mothers, fathers, children, and others going forward. So thank you, Mr. President.
Question is, shall the Senate adopt the report of the Committee on Health and Welfare? Are you ready for the question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay. The ayes have it, and you have adopted the report of the Committee on Health and Welfare. The question now is, shall the bill be read a third time? Are you ready for that question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay. The ayes have it, and you've ordered third reading of H 661. We will now continue on with H 847. H 847 was read for the first time, referred to the Committee on Health and Welfare, which considered the same, and recommends that when the bill is amended, the bill ought to pass. The bill is then referred to the Committee on Finance, which also considered the bill and indicated that when the bill is amended, the bill ought to pass. And then the bill went to the Committee on Appropriations, which had the same conclusion, which was that when the bill is amended, the bill ought to pass. Please listen to the second reading of the bill.
H 847, an act relating to peer support provider and recovery support specialist certification.
Now you've heard the second reading of the bill. For the report of the Committee on Health and Welfare, the senator from Chittenden Central.
Thank you, Mr. President. A few weeks ago, we heard very powerful testimony in health and welfare from someone in recovery from substance use disorder. She told us the first time she tried opioids was in middle school. She came from a background filled with trauma, chaos, instability, And she remembers standing in the middle school bathroom and feeling the effects of the Percocet. She said as the drug took hold that she knew this was going to be how she was going to get through life. That testimony stuck with me, and more than anything I've heard really described how opioids can take up residence in a body and a brain. She's in recovery now. She helps others struggling with addiction, and anyone who's ever suffered from addiction or has been close to someone with a substance use disorder knows how incredibly difficult it is to recover from this illness. It often takes years to recover and requires a multitude of strategies and approaches. One of the most important elements of recovery is support. Support from family, community, employers, and in short, peers. Enter peer support providers and peer recovery support specialists. These folks are another tool in the toolbox. These individuals show up day after day and provide a panoply of services and assistance to help a person in recovery regain a sense of hope through self-advocacy. Peer support providers assist with health and wellness supports. They help individuals access community-based resources and navigate state and local systems. They provide employment support. They have lived experience and are non-judgmental in their approach. Peer recovery support specialists do many of the same tasks as the peer support providers. However, their work's a little bit more structured. They work within a set of culturally competent, non-clinical, evidence-based activities. They coordinate their work through a written, individualized recovery plan of care with measurable goals. Their lived experience can either be through their own personal recovery or from a substance use disorder, or through a close relationship with an individual in recovery. H847 is a bill that relates to the regulation and the certification of these peer supporters. If you look at the bill, you'll see that in sections 1 through 3A, those sections will add peer support providers and peer recovery support specialists to the list of professions regulated by OPR, Office of Professional Regulation, and gives OPR the authority to do criminal background checks. These chapters also set fees. Section 4 adds a whole new chapter, 26 BSA, chapter 60. And here you've got subsection 3191, which adds definitions, subsection 3192, which states that only certified providers can call themselves a certified peer support provider or a certified peer recovery support specialist. So this bill does not prevent the work of non-certified providers, but if you're going to do the work and you're not certified, you can't call yourself certified. That's what this is saying. Subsection 3193 outlines the lists of duties of the director of OPR with regard to certified peer support providers and certified peer recovery support specialists. Subsection 3194 requires the Secretary of State to appoint advisors to the director for 5-year staggered terms. Subsection 3195 lays out the eligibility requirements to become certified. For example, a completed application, application fees, evidence that the applicant is 18 years of age, has received a credential from the relevant credentialing body, and that's authorized by the Department of Mental Health, and has passed registry checks and criminal background checks. Subsection 3196 is about certificate renewal. 3197 is about unprofessional conduct. Subsection 5 is rulemaking, and subsection 6 is effective dates. There is a fiscal note to this bill, but I know my colleague from Orange will discuss that with you. We have a really long list of witnesses. I will just read a few to you. Brian Atwood from the Public Health Policy, who is the Public Health Policy Director for the Department of Health, Gary DeCarolis, Executive Director of Vermont Recovery Network, Kelly Doherty, Deputy Commissioner, Department of Health, Zachary Hughes, Board Vice President, Vermont Psychiatric Survivors, Lauren Lehman from OPR, Chip Mitigee, who's a recovery coach at the Turning Point Center of Addison County, Wilda White, who's a consultant in the Peer Workforce Development Initiative, and many, many others. Our vote in committee was 5-0-0, and we ask that you join us in supporting this bill. Thank you, Mr. President.
The bill was then referred to Committee on Finance for the report of the Committee on Finance, Senator from Orange.
Mr. President, the senator from Chittenden Central has outlined the new group of professionals that will be given certification to perform their tasks. If you look on page 3307, you will see the license, the certification or license fees they pay. And it's $50 to be certified and $50 for the biennial renewal. The amount of money raised for this group is de minimis. The landing that these new professionals have is gentle at $50 compared to others. And when there's a reason to change that, perhaps a future legislature will change the number. But it is a de minimis amount, and we welcome the new Vermont professionals. Thank you, Mr. President.
Bill is then referred to Committee on Appropriations for the report of the Committee on Appropriations, Senator from Chittenden Southeast.
Thank you, Mr. President. Committee on Appropriations reviewed the bill and understand that there will be an initial cost to the Office of Professional Regulation to implement the certification programs, but that beginning in 2026, there will be additional income from the fees. And then by 27, some of the fees will go up. And so we understand that the costs will be covered in our current budget for the implementation of this. And we recommend that we approve the bill as written. Thank you.
So the question is, shall the Senate adopt the report of the Committee on Health and Welfare? Are you ready for the question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay. The ayes have it, and you've adopted the report of the Committee on Health and Welfare. The question now is, shall the bill be read a third time? Are you ready for that question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay. The ayes have it, and you've ordered third reading of H 847. It's my understanding we're going to pass over H 882 for the moment due to time potential concerns. And we're going to move on to S 209 found on 3493 of today's calendar. The House has referred over a proposal. So the pending question would be, shall the Senate concur with the House proposal of amendment? It's my understanding there's an amendment to be offered in the calendar on 3502. I'd like to recognize the Senator from Chittenden Central.
Thank you, Mr. President. I would direct the Senator's attention to page 3502, as was just stated. I'll begin by saying that I think our counterparts in the other body did fine work on this bill. Senators will remember this is the bill to deal with the problem of ghost guns, printed guns, 3D printed guns, or guns constructed with parts and kits received over the internet. And by and large, the House has seconded our work on ghost guns. They've added some material of their own. So what I will do is walk senators through. This is our concur with further proposal. And there are only 3 areas really where we now diverge from the House. We have been in discussions with them, and we believe that they will look favorably on this amendment if we move it over to them. So if senators could move to page 3504. You might remember that in the bill we sent to the House, we had a series of criminal penalties, three tiers of criminal penalty. The House was not as comfortable with that as we were. They made them civil penalties. Our committee balked at that because we felt that civil penalties, especially at the level that the House was talking about, in their version, it was $50 civil fine for a first offense, $250 civil fine for a second offense. We thought that weakened the bill. And so what we've done here is, by way of compromise, if someone does not serialize their 3D printed weapon or their kit that they put together in their basement, and law enforcement finds that out, they would have, as a first offense, a civil penalty of $50. If they are caught again, it would be a criminal offense, and you'll see at the bottom of 3504, for a second offense, criminal, imprisoned for not more than 2 years or fined not more than $1,000 or both. The thinking there being that on a second offense, someone can't claim ignorance. At that point, there's a pattern of behavior and the criminal penalty is incurred. So again, we believe that that will be acceptable to the other body. The other place I would ask senators to go is page 3507. If on that page, you look down from the bottom to subsection 3, in the original bill, for the 3-day waiting period, there was a 1-year sunset for gun shows. And the idea was to allow gun show operators and people who are used to that method of buying a gun to have a year in which the 3-day waiting period did not apply. The House, in their proposal, asked for a second year, which we did not see logic to doing because people are already on notice and have been for a year. And we thought that lifting the waiting period for gun shows was perhaps the worst place to lift it. So you'll see we did not agree with the House on that piece. Just below that, 3F, I will read it. This section shall not apply, that is the 3-day waiting period, to the return of a firearm frame or receiver to a person by a licensed dealer after the dealer has serialized it. So the sequence would be this. Someone has what we consider a ghost gun. They take it to be serialized. When they get it back, they must complete a background check. But we have agreed with the House that they need not wait 3 days. And the thinking there is that they had possession, they turned it over of their own free will to the FFL to be serialized. So there doesn't seem to be a need to wait 3 days for them to get that weapon back. So that was a recognition that the House had made a logical move there, and we support that. Then down below, you'll see the major addition that the House made. So we talked some years back about what are called safe spaces. And that's a phrase taken from a Supreme Court decision some years ago in which the majority ruled that there are places where you can prohibit guns because they're especially sensitive places. And so schools, hospitals, etc. So following that logic, the House has here indicated that polling places, and this is built, as all of you know, on not merely anxiety about polling places, but actual threats to polling places over the last number of years. So what this does is it prohibits firearms in polling places knowingly carried. So there's you'll see on 3507, section 413 VSA 4027, the word knowingly is there, and that's key for a prosecutor to prove that the person understood that they were carrying the weapon and that it wasn't accidentally on their person. But the major difference here, in addition to adding this, is that the House wanted to make this section prohibit not just firearms, but also deadly weapons. Deadly weapons can include knives, which can include jackknives that someone might have on their person, So our committee removed that, and we are sticking just with the idea that firearms would be prohibited in polling places. I think this is a key addition. I thank the House for it, because as I mentioned earlier, we are in a strange moment in the history of the United States where polling itself is under attack. And I mean that rhetorically, I mean it politically, but I also mean it literally. And so I think this is a fine signal to send in an election year that in the state of Vermont, we will not allow our polling places to be places of anxiety or threat. With that said, Mr. President, I'll just point out that in section 7, there is a report on firearms in municipal buildings. Again, in terms of sensitive spaces, about 4 years ago, I proposed a bill in which municipal buildings, government buildings, including the State House, you would be prohibited from carrying a firearm. That did not go all the way through the process, but one piece of it, the ban on guns in hospitals, did. But what the House is doing here is returning to that discussion, and they've taken a cautious approach to set up a study to look at different methods where we might do this. People have proposed an outright ban on all government buildings or municipal buildings. Some people believe it would be better to do it town by town, select board by select board. So there are different theories out there, and this study would be to look at them and try to decide on a common approach if one is to be adopted. So with that said, Mr. President, as I overall indicated, we think this is a fine response from the other body. It strengthens some of our work, and we believe we have an agreement to preserve the Senate's position on things that were important to us. And I'm happy to answer any questions, and I believe our vote on this was 4-1-0.
Now, the senator from Chittenden Central and others move that the Senate concur with the House proposal of amendment with further proposal of amendment as found on page 3502 of today's calendar. Are you ready for the question? Senator from Windsor.
Thank you. I am so grateful for these amendments that the Senate has done, and for the House adding pieces that some of your senators had proposed in the Senate to take up. So we're thrilled the House added polling places and deadly weapons. My question, if I may require of the reporter of the amendment, I would love to do so.
The senator from Chittenden Central is interrogated.
Thank you. My question to the reporter is, in section D1A and B, are these offenses per gun or per person? So if a person is creating several 3D guns, and is this per offense, per gun, or is it per person?
Could I, Mr. President, ask the page number that the senator?
Oh, sorry, 3504.
3504. Thank you. So there are, here we're talking about possession, and I believe for possession, it would be one penalty, regardless of the number of guns. We also have manufacture elsewhere in the bill that would potentially be a different.
And would manufacturing take into account the number of guns that were being produced by an individual?
I don't believe you'd have multiple penalties for multiple weapons. I believe there would be at the time of prosecution, one charge.
Okay. Okay. Thank you. That answers that question. Thank you very much.
Thank you.
Question is, shall the Senate concur with further proposal of amendment on S209? Are you ready for the question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay.
No.
The ayes appear to have it. The ayes do have it. And you have concurred with the House proposal amendment on S209 with further proposal amendment as offered by the senator from Chittenden and others. My understanding is we will now continue on to 614, which is found on page 3554 of today's calendar. This bill was referred to committee, read the first time, referred to Committee on Agriculture, which considered the same and recommends that when the bill is amended, the bill ought to pass. Please listen to the second reading of the bill.
H 614, an act relating to land improvement fraud and timber trespass.
Now you've heard the second reading of the bill for the report of the Committee on Agriculture, the Senator from Lamoille.
Mr. President, 614 can be found in today's calendar on 3554. And as stated, it is an act relating to land improvement, fraud, and timber trespass. This has long been an issue that has been a problem in rural Vermont, and people coming onto other people's lands and taking timber when there's logging operations in neighboring pieces of land. I think I got the pleasure in dealing with this, and if I can tell a personal story, I was in my first term in the legislature, and at that time, the member from Johnson in the other body was, had long been a game warden, and we're driving home, and he goes, they're logging some land up on that hill, and it's right next to an elderly woman who was in her late 80s property. And he said, she's homebound and she can't get out to see what's going on. And I'm pretty clear that the loggers that are logging next door are on her property. And so we ended up going up and checking, and certainly they were. And he said to me, we'll go to the lumber mill where we know this lumber is going, and we'll present them with a bill the next week when we're headed to back to the legislature. And we did that. And so, we weren't very popular when we went in this mill, and we were presenting them with the stumpage and the cost of the lumber. And when we came back that Friday, we got a check. They sent me in to get the check. I was all of 23. I was a little nervous going in. And we delivered that check to this elderly woman. I'd say she was probably 78, she was probably 87 or 88. And she cried, and because she didn't have very much, but she owned this 60-acre piece of land. So the issue of people going onto other people's lands and stealing timber has long been a problem, and it's a really hard problem to deal with when you've got loggers that are coming and going, and you've got absentee landowners, and you've got elderly people with land beside that can't get to the property to see, and sometimes the owner of these properties don't know what's happening for months down the road, and the people that did the logging next door are long gone. So this is our attempt with the House to deal with that issue. What we do is increase fines, we increase jail time, we create a security bond system, we increase the security bond, and there is a fraud registry in the AG's office, and all of that is dealt with. So in the bill, section 1 of the bill amends 13 VSA 2029, which is the home improvement and land improvement fraud section in statute. So 614 in section 1 expands the scope of home services and the definitions around home services. It tightens up the language for forestry operations as defined in 10 VSA 2602, including construction of trails, roads, and structures associated with forestry operations and the transport of off-site trees, shrubs, and timber. And it expands there. Also in section 1, 614 also increases to 1,000 the value of a contract that triggers home or land improvement fraud. Under current law, the contract threshold is 500, so they double the threshold. The Senate Ag Committee, also in section 1, required the registry to indicate whether the person filed a security bond under subdivision 2029E in order to continue to operate after a violation. So after you had a violation, you have to have a security bond or some sort of financial security. In those cases, to do that, you know, if you've got some logger that is coming and going, this gives them a place to go to get when there is damages. 614 amends the amount under subdivision D1 that triggers a penalty of not more than 2 years of imprisonment or fine of more than $1,000. So it deals with the jail time involved. 614 amends the trigger of this penalty, increasing it from a loss of less than 1,000 to a loss of 1,500. So if you have a loss of more than $1,500, it goes into effect. That's a pretty low bar because when, particularly when you have hardwood timber and a lot of softwood timber now, it can be well up into the thousands of dollars that that people can lose in this. 614 increases, when we talk about a financial bond, increases in section 1, the financial bond or security requirement from 50,000 to 250,000. It also clarifies how a convicted person can continue to work in the field. It increases those bond requirements for people working in the field. Section 2 of the bill is the timber trespass, financial security, and seizure. So it adds a new section to 13 VSA, Chapter 77, which is the chapter that provides for timber trespass. It talks in this section, timber trespass occurs when a person knowingly or recklessly cuts down, fells, destroys, removes, injures, damages, or carries away any timber or forest product placed or growing for any use or purpose whatsoever, or timber or forestry product lying or growing beyond to another person without the permission of the owner. The Senate Ag Committee, also in section 2, provided a penalty for a person that fails to post the required bond or fails to inform the Attorney General of their work in this business. Informing the Attorney General is where it comes in because they have a fraud registry. In section 3, which is the timber trespass and criminal penalties, we move this, the Ag Committee increases from 2 to 3 years the potential imprisonment of a second or subsequent offense for timber trespass. So it's 3 years potential imprisonment for this. And I might say at this point, normally this would have gone to judiciary, but the 2 chairs of both Ag and judiciary work quite closely with each other to come up with this. Let's see, section 4 is the implementation section of the bill. It adds clarification about the bond and financial security. And section 5 is the timber trespass enforcement piece and gets a report back. And section 6 is the effective date. The Committee on Agriculture voted 5-0-0 in support of this. We had 10 witnesses and we had the members of the other body that had reported this, that sponsored it. We had Ledge Council, we had Forest and Parks, we had Forest Products Association, and we had the Bankers Association in on the bill.
Question is, shall the Senate adopt the report of the Committee on Agriculture? Senator from Chittenden Central.
Thank you, Mr. President. I want to thank the senator for answering a question that was posed by the Lorax and has troubled me for many years, and that is who will speak for the trees?
Question is, shall the Senate adopt the report of the Committee on Agriculture? Are you ready for the question? If so, all those in favor, please indicate by saying aye. Aye. Those opposed indicate by saying nay. The ayes have it, and you have adopted the report of the Committee on Agriculture. The question now is, shall the bill be read a third time? Are you ready for that question?
Roll call.
Roll call has been requested. Are you ready for the question? If so, the secretary shall commence to call the roll.
Senator Ruth,
Yes.
Senator Gray,
Yes.
Senator Brock,
Yes.
Senator Campion,
Yes.
Senator Chittenden,
Yes.
Senator Clarkson,
Yes.
Senator Caldwell.
Yes.
Senator Cummings,
Yes.
Senator Yulee,
Yes.
Senator Hardy,
Yes.
Senator Harrison,
Yes.
Senator Hashim.
Yes.
Senator Ingle.
Yes.
Senator Kitchell,
Yes.
Senator Lyons.
Yes.
Senator McDonald,
Yes.
Senator McCormick,
Yes.
Senator Norris,
Yes.
Senator Pershling,
Yes.
Senator Ron Hinsdale,
Yes.
Senator Sears,
Yes.
Senator Starr,
Yes.
Senator Bihowski.
Yes.
Senator Watson.
Yes.
Senator Weeks,
Yes.
Senator Weston,
Yes.
Senator White,
Yes.
Senator Williams,
Yes.
Senator Renner,
Yes.
Please listen to the results of your vote. Those voting yea, 29, those voting nay, 0, and you've ordered third reading of H 614. Senator from Chittenden Central.
Thank you, Mr. President. Pending announcements, I would move that we stand in recess, that we adjourn until 1 p.m. And if I might begin the announcements, Mr. President.
You may.
That was a pretty perfect hard stop at noon. We have half an hour for senators to eat. Just a reminder that we will be having an all-member caucus on the floor to discuss our work that's coming up on 687, an act relating to community resilience and biodiversity protection, the Act 250/housing bill. So at 12:30, we will begin a half an hour of explanation and discussion while we are not in session. And then we'll gavel back in at 1 o'clock for the regular afternoon session. Thank you, Mr. President.
Are there any announcements? Seeing none, the senator from Chittenden Central has moved that Senate now stand adjourned until 1 p.m. today. Are you ready for the question? If so, all those in favor, please indicate by saying aye. Aye. Those opposed indicate by saying nay. The ayes have it, and the Senate will stand adjourned until 1 p.m.